of minors, but not to the prurient interest of adults. And the same thing with patent defensiveness, and the same thing with social value. And he's saying, well, basically, this is just another way to outlaw obscene material, and maybe there's some borderline cases that the law would pick up. Those could be challenged on an as applied to that particular kind of stuff basis, and doesn't justify killing the law across the board. Tina? Yeah, I think that's possible, and you could conjure up examples that would go both ways. Where does that take you?
Doesn't that take you to the idea that just that the law itself isn't fit, if it blocks things that adults have every right to?
It isn't vague. No, but it's overbroad. It's overbroad if it blocks material, or if it bans material that adults have every right to see, then it's overbroad. The fact that it's done in the name of protecting children doesn't deal with the overbreadth point, with the non-narrow tailoring point. So the case goes back to the trial court, and they had a trial about whether filters are effective or not. And the trial judge decided that they were effective, that the law was therefore not narrowly tailored. On the overbreadth point, I mean, giving the government the opportunity to make a better case actually backfired for the government, because the trial judge took additional testimony showing how wrong the law was, that it didn't target just commercial pornographers, that there were nonprofit sex education sites, for example. There was salon.com would have been caught up in this harmful to minors net because it had photographs from the Kinsey Institute. It had Japanese erotic woodcuts on it. That there were lots of non-pornographic sites whose materials would have violated this law. And perhaps more troubling is when you're talking about material that is harmful to minors, don't you have to distinguish between toddlers and sophisticated 17-year-olds? Material that may be considered harmful or in some way inappropriate for a 5-year-old may not be at all for a 17-year-old, and yet they're all treated the same under this law. And the court re-emphasized that the terms were vague and that people would have to guess at the meaning, and that they would have to guess at things like the social value. Does this material have literary value for a toddler, for a 5-year-old? Does it have literary meaning, value for a 17-year-old, and so on? The case went back to the Court of Appeals, which affirmed, now we're in permanent injunction territory. There's been a trial. The government has had a full opportunity to make its case. Now a permanent injunction against the law has been issued, and it goes back to the Court of Appeals for the third time. And the government has a new argument here. It's the belt and suspenders argument, saying that nothing prohibits the Congress from using a belt and suspenders approach to protecting minors from harmful material on the web. Filters can act as the belt, and COPA, the criminal prosecution, can act as the suspenders. But the Court of Appeals says under the First Amendment, if the belt works at least as effectively as the suspenders, then the government can't prosecute people for not wearing suspenders. So that's the effect of filters. And the government took one last shot at the Supreme Court, one further appeal. They argued that only about half the households where there are computers use software filters. I'm surprised there are that many. But the government was arguing, look at the millions of other American children who are not being shielded by software filters. Don't you have to do something about that? The court denied certiorari in January of 2009, and COPA was dead. Like the CDA was interred with Reno, COPA is dead after the round two. Kristen. There were two decisions by the Supreme Court, the one on community standards, the one on the preliminary injunction, and then there was a certiorari denial on the merits on the permanent injunction. The court had already said everything that it needed to say by the time the case reached there the third time. All these appeals to the Supreme Court, that's why I said when we were talking about the new Ninth Circuit decision from 2 weeks ago about commercials on public television, where the court struck down two provisions of the law, provisions that prohibited public stations from airing public issue commercials or political ads. It seems to me that the government's not going to roll over and say, well, that's what the law is, therefore we quit. I think they will appeal it every place they can, seek rehearing in the Ninth Circuit, and follow it with an attempt to get the Supreme Court to hear the case. The court has upheld one of Congress's attempts to regulate indecent material. Let's see, Ashcroft was the name of the case, the opinion by Thomas on community standards. So it was Ashcroft versus ACLU, and then there was Ashcroft versus ACL number 2, COPA number 2. That was the Kennedy decision about software filters and their utility. And then the law that the law that survived Supreme Court scrutiny was SEPA, the Children's Internet Protection Act, which was a bill authored by Senator John McCain that provided that libraries, schools and public libraries both, that use federal funding for internet access from the library, which is virtually all schools and virtually all libraries use federal funding for that they are required to install filters on their computers to block access by minors to, quote, visual depictions that are, quote, harmful to minors. Nothing defined. No definitions in the law. And the law was challenged by the American Library Association, among others, plaintiffs, in a similar kind of challenge to the law that the ACLU had mounted in the CDA and the COPA case. In the SEPA case, it was the American Library Association that was the lead party. The case ominously titled United States of America versus the American Library Association. And And the opinion in the case, written by Chief Justice Rehnquist, said that Congress had every right to require the recipients of federal largesse, of federal funds, to install software filters, that Congress can attach conditions to any federal money that it decides to use by way of subsidy to libraries. The court emphasized that what you're dealing with here is not a criminal law that scares the bejesus out of people for fear of saying something that will land them in jail. This is not a criminal law. It's simply a requirement that libraries will use federal money, install software filters. And the court was somewhat concerned, at least in the argument of the case. Several justices asked about the phenomenon of overblocking of filters, overblocking protected material, and in particular, material that adult users of the libraries would like to get access to. And the Solicitor General of the United States, I think it was a deputy, this was pre-Verrilli days, a deputy Solicitor General said, "Oh, Your Honors, you don't have to worry about that, because if an adult wants access to a blocked site, all he or she has to do is go to the librarian, and the librarian will come running and unblock the site for the adult." Oh, sure. That's great service in a library. And on that basis, if that's what would happen, so that adults wouldn't be deprived of access to material that's perfectly appropriate for them, the court agreed that the law was constitutional. Two of the votes making up the majority were Kennedy and Breyer, who concurred in Rehnquist's opinion explicitly on that understanding, that librarians would unblock sites for adults upon request, which seems a little unrealistic, but that's the way the court came out. I'm pleased to say that after the decision, the San Francisco Public Library decided to refuse federal money rather than install filters and censor material for the citizens who come and use the San Francisco Public Library. I don't know what they've done in Berkeley. I don't think they have filters, but I'm not sure. In any event, those were the principal decisions dealing with the internet. We're not quite finished with that subject. We'll finish it up on Thursday, then I'll leave some time for evaluations and so on in the review session next Tuesday. We'll get all your questions answered.